All right, so get ready because today we are going deep into Philippine energy regulations.
Oh, this is going to be good.
Yeah, we've got a fascinating case here.
Yeah.
One that went all the way to the Supreme Court.
Wow.
It all comes down to selling transmission assets
Yeah.
and this really crucial requirement to form a consortium.
I see.
You want to understand what happened
Yeah.
with the sale of the Dasmariñas-Alabang-Rosario 115 kV line, right?
Yeah, that's the one.
Like, why was forming a consortium such a big deal in this case?
It's a good question, yeah.
Yeah.
This case is really interesting.
Yeah.
It shows just how complicated it is
Uh-huh.
to try and privatize these assets while also making sure the energy market stays stable and fair.
Yeah. Okay, so let's set the stage a little bit.
Okay.
It's December 2011.
Right.
And we have the National Transmission Corporation, TRANSCO.
Right.
They're looking to sell off some of their subtransmission assets to the Manila Electric Company, or Meralco, as most people know it.
Yep.
So basically, yeah, TRANSCO's cleaning house, and Meralco wants to buy some stuff. Exactly. So when you have this kind of sale, the Energy Regulatory Commission, the ERC, has to sign off on it.
Right. They have to approve it.
And they did approve some of the assets in this deal.
Yeah, like the Tayapa's 115 kV switch yard.
Right. But then they put a hard stop on selling the Dasmariñas-Alabang-Rosario line.
Right, the dire assets.
So some things were okay to sell, but not others.
Correct.
What made this particular line so different?
Well, it's because the DR assets provide electricity to a pretty important area.
Okay.
The Cavite Economic Zone,
All right.
which is managed by PEZA, the Philippine Economic Zone Authority.
Gotcha.
So the ERC was really worried
Uh-huh.
that just transferring ownership over to Meralco
Right.
without any other players being involved
Yeah,
could seriously disrupt things in the zone.
I see.
They were worried about power outages, service disruptions,
Oh, wow.
and what that would mean for the quality and the reliability of the electricity supply.
So they weren't just being difficult.
No, well,
They were thinking about the bigger picture,
exactly.
the impact this would have on businesses and residents in the zone.
Right, because everyone needs reliable power.
That's true.
If one company has control over all the transmission lines, then they essentially have all the power.
Literally.
Yeah, literally.
Yeah.
And that means they could just raise prices.
Oh, because everyone's stuck with them.
Exactly.
So the consortium requirement, it's
Yeah.
there to prevent that kind of scenario.
It's like a safety net
It is.
to make sure no one company gets too much control.
Makes sense.
Now, of course,
Yeah.
Meralco and TRANSCO weren't exactly thrilled with this requirement.
I bet not. They probably weren't just going to say, okay, never mind.
No, they pushed back.
Right that day.
They argued that PEZA, the zone manager, had already said they didn't want to buy the assets.
Interesting.
Their logic was, if PEZA's not interested, then why do we need a consortium?
So no buyer, no need for a consortium.
That was their argument.
Did it work?
Not even close.
Really?
This sparked a huge legal battle
Wow.
that went all the way up to the Supreme Court.
I bet.
The Court of Appeals initially actually sided with Meralco.
Oh, really?
But then the Supreme Court stepped in and said,
right.
hold on.
Oh.
They completely overturned that decision,
Whoa.
siding with the ERC's original ruling.
Big decision.
Huge.
So why? Why was the Supreme Court so insistent on this consortium requirement?
Well, they focused in on one very specific part of the law.
Okay.
Section 8 of the Electric Power Industry Reform Act of 2001.
EPIRA.
Yes, EPRA, that's the one.
The rule book for the entire power industry.
That's a good way to put it.
And it lays out very clearly that when you're transferring ownership of these types of assets that serve multiple distribution utilities,
Right.
you have to form a consortium.
It's mandatory.
There's no way around it.
The law uses the word shall, not may or should.
It shall.
Very clear.
Yeah, that's the legal word that slams the door shut. Exactly.
No wiggle room.
Nope.
So they were basically saying, this isn't a suggestion, it's the law.
Exactly. And they had some good reasons for taking this stance.
Okay, like what?
Well, for one, they said that allowing waivers would set a dangerous precedent.
How so?
Well, imagine a company wants to avoid forming a consortium,
Uh-huh.
so they pressure someone to withdraw their interests.
Oh, I see.
And suddenly the whole system that's designed to keep things fair just crumbles.
So it's not just about this one case.
Right.
They're looking at the long-term health of the whole industry.
Exactly, thinking about the big picture.
Wow. It's interesting how this technical requirement has such wide-reaching implications.
It really does.
But what about the constitutional side of things?
Good point.
Did the Supreme Court address whether forcing a consortium was even legal.
They did, yeah. They looked at it from all angles. And ultimately, they said that the consortium requirement doesn't violate the Constitution.
Okay.
Their argument was that it doesn't prevent privatization. Okay.
It just makes sure it happens in a way that's fair and balanced.
So it's more about setting up guidelines
right.
than preventing the sale altogether.
Exactly. It's about making sure everyone plays by the rules.
I see.
And they actually pointed out
yeah.
that it doesn't even stop Meralco and PEZA from working together.
Okay.
They could still have agreements outside of the consortium structure.
Interesting.
So it's not about making things difficult for them.
Right.
It's about having a framework in place
right.
that protects everyone involved.
Gotcha. So we've established that this consortium requirement, it's a pretty big deal.
Definitely.
It's rooted in EPIRA.
Right.
And it's not going away anytime soon.
Not at all.
But what does Section 8 actually say about how these subtransmission assets should be managed after they're sold?
Well, it gets into the nitty-gritty of it all.
Does it?
It lays out that forming a consortium or some similar legal entity is the way to go.
Like the preferred way to handle this.
Exactly. It even goes as far as to say that this consortium should be granted a franchise to operate the assets.
Interesting. So instead of just handing everything over to Meralco, they're saying, let's create a shared ownership structure.
Yeah, I have multiple parties involved.
Checks and balances right there in the ownership structure.
Exactly.
That's smart.
This is.
But I'm sure Meralco didn't give up that easily.
Oh, they definitely didn't.
They had more arguments, didn't they?
Oh, yeah. They had some clever legal strategies.
Like what?
Well, they actually tried to reclassify the DDR assets.
To get out of this requirement.
To avoid Section 8 altogether.
Oh, sneaky. Changing the label on the box.
Something like that.
What happened there?
Well, that's where things get even more interesting.
Oh, boy.
And we'll have to unpack that in the next part of our deep dive.
All right. Sounds good. We'll be right back after a short break.
So, yeah, we were talking about Meralco trying to reclassify those assets.
Right, to get out of that consortium requirement.
Exactly. Pretty clever move, right?
Yeah. Yeah, like changing the label on a box to avoid shipping regulations or something.
Yeah, something like that.
So did it work?
Well, they argued that the Dasmariñas-Alabang-Rosario line, those DR assets, they shouldn't even be considered subtransmission assets anymore.
Oh, so if they could pull that off,
right,
the consortium requirement wouldn't apply at all.
Exactly.
Yeah.
Their reasoning was that the assets were going to be connected to a specific power plant.
Oh, right.
Which they claimed would change their function.
Okay.
And basically make them exempt from Section 8 of EPIRA.
So it became a battle of legal interpretations then?
It did.
Like something out of a courtroom drama?
Yeah, but...
What did the Supreme Court have to say about all this?
Well, they didn't just take Meralco's word for it.
Right.
They dug into the implementing rules and regulations of EPIRA.
Oh, wow. So like the detailed instruction manual for the law.
Exactly.
To see if this reclassification argument held up.
Yeah. They wanted to make sure Meralco was playing by the rules.
Not trying to bend them.
Exactly.
And of course, it's the Energy Regulatory Commission, the ERC.
That's the expert body that makes these classifications.
Right, right.
And the Supreme Court found that the ERC had already considered all the technical stuff.
Okay.
And it determined that the DR assets, even with the proposed changes, still fit the definition of subtransmission assets.
So they basically said, trust the experts.
Yeah, the EOC knows what they're doing.
Makes sense.
Unless there was clear proof of a mistake.
Right.
Or misuse of power.
Yeah, they weren't going to second guess the regulatory body.
Yep.
But what about everyday Filipinos?
Good point.
Did the Supreme Court consider how this would affect electricity rates?
Yeah, of course, that's super important.
For consumers, yeah.
Yeah, and Meralco actually argued that this reclassification would lead to lower electricity rates.
Really?
For everyone.
Oh, wow.
Both inside and outside the Philippine Economic Zone.
Okay.
They even had data and simulations to back it up.
So they were saying, trust us, this is good for everyone's wallets.
Yeah, basically. But the Supreme Court, always thorough, they took a closer look at that data.
Okay.
And they found some issues.
Like what?
Well, Meralco hadn't fully accounted for things like connection charges and residual subtransmission charges, which could offset any savings.
Right.
They also pointed out that the simulations didn't consider certain scenarios.
So their conclusions weren't that reliable.
Exactly.
It's like the Supreme Court was saying, nice try, but show us the whole picture, not just the parts that help your argument.
Exactly. They emphasized that you need a complete analysis.
Right.
when you're making claims about electricity rates.
So they were really looking out for consumers.
They were.
But let's go back to Meralco's argument for a minute.
Okay.
They claimed that being forced into a consortium with PEZA would make it harder to manage the assets.
Really?
And could even hurt their ability to serve customers in the zone. Oh, wow. So were they just trying to protect themselves?
Well, maybe partly.
Or was there something to their concerns?
I mean, it's possible that things would be simpler without PEZA involved.
Right.
Decisions could be made faster.
Less bureaucracy?
Yeah, they could be more responsive to the zone's needs.
So basically they were saying, we can do a better job on our own.
That was their argument.
But the Supreme Court wasn't buying it.
Nope.
They acknowledged that there might be some complexities.
Right.
But they kept coming back to the purpose of the law. Which is to create a stable and balanced power market.
Right.
They saw Meralco's argument as speculation.
Okay.
And not strong enough to outweigh Section 8.
The consortium requirement.
Exactly.
So the bigger picture was more important
Do it.
than the potential convenience for one company.
Right.
But didn't they offer some kind of compromise?
They did, yeah.
What was it?
They said that Meralco and PEZA could still collaborate through agreements outside of the consortium structure.
Yeah.
So they could still work together.
Right.
But within the law.
Exactly.
It's not about preventing collaboration then.
No.
It's about setting up a system that's fair.
And prevent abuse.
Right, checks and balances.
Exactly.
So the Supreme Court was saying that the consortium requirement wasn't meant to be a roadblock.
Okay.
It's about creating a more transparent system.
For managing these assets.
Right. Shared responsibility.
Accountability.
Exactly.
Was this a unique decision, though? Or is this how the Supreme Court usually handles these cases?
It's definitely part of a pattern.
Okay.
They've consistently upheld the consortium requirement.
Really?
In similar cases.
Huh. Interesting.
It's not a one-off ruling.
It's like a legal precedent now.
Exactly.
That's important.
Right.
Very important. So businesses know what the rules are.
And that they'll be applied consistently.
No one wants to play a game where the rules keep changing.
Exactly.
And it creates a more stable environment for everyone, for investors, for companies. Encourages participation in the market.
Makes sense.
It does.
But before we wrap up,
Yeah.
I think we should highlight how the Supreme Court emphasized EPIRA.
Right. The Electric Power Industry Reform Act.
They really focused on the purpose of that law.
They did.
And how it relates to this case.
They said that the core objective of EPIRA is to make sure Filipinos have reliable and affordable electricity.
It's about serving the public good.
It is.
And they said that the consortium requirement is key to achieving that goal.
Okay.
It's about making sure privatization benefits everyone.
Not just a select few.
Right.
So it's not just about legalities.
No.
It's about making sure the power sector works for the people.
Exactly. Privatization with a purpose.
I like that.
Me too.
So now I'm really curious to hear the final verdict.
Oh, yeah, it's a big one.
What happened? What did the Supreme Court ultimately decide?
Well, let's get into that in the final part of our deep dive.
Okay, so we've gone through all the arguments.
Yeah. The Supreme Court's analysis, everything. What was the final decision?
Well, the Supreme Court sided with the National Grid Corporation of the Philippines.
NGCP.
Yeah, NGCP, that's the one.
They were the ones who really pushed for the consortium, right?
Yeah, they were the ones who initially challenged the sale.
Oh, right.
Arguing that it couldn't go through without a consortium.
So the Supreme Court completely overturned the Court of Appeals decision.
Completely, yeah. They went back to that original ERC order.
So the sale of the Dasmariñas-Alabang-Rosario line.
The DR assets, yeah.
It could only go through if Meralco and PEZA formed a consortium.
Exactly. They even went a step further.
Did they?
They said that this consortium
Yeah.
would need to get a franchise from the ERC.
Before they could even operate the line.
Right.
A complete victory for NGCP then?
And for the ERC.
They really stood their ground.
They did.
What about Meralco, though?
Oh, well, this threw a wrench in their plans, for sure. I bet. Imagine. They have to go back to PEZA now.
Who initially didn't even want the assets.
Right, and now they got to figure out how to work together.
That must have been an interesting conversation.
I bet it was.
A little awkward after all that back and forth.
Probably.
But if they wanted those assets, they had to make it work.
They did.
This case really shows that even in big business deals,
the
law still matters.
Absolutely. No one is above the law.
It's a good reminder for anyone in the power sector.
Yeah.
You gotta understand the rules.
And respect the regulatory framework.
EPIRA especially.
EPIRA is key.
And it shows how important judicial review is.
That's true.
The Supreme Court really stepped in to correct what they saw as an error.
Yeah, they set a precedent, too,
with this decision.
that will echo through the whole industry.
This consortium requirement is not just a suggestion.
Right.
It's vital.
For a stable and fair market.
So for someone who's been following all this, what are the big takeaways from this case?
Well, the biggest one, I think, is that EPIRA and the court decisions about it, they have a huge impact on the power industry.
Makes sense.
Anyone involved needs to understand how these laws work.
How they affect their interests.
Right, because no one is above the law.
Not even a big company like Meralco.
Nope.
And the Supreme Court is there to make sure things stay fair.
And to uphold that idea of a balanced energy market.
This case was really all about that, wasn't it?
It was.
Checks and balances.
The rule of law.
Making sure the power system works for everyone.
Affordable and reliable energy for all Filipinos.
Now, this case also raises some interesting questions about the future, doesn't it?
It does.
Yeah, like how will this decision affect future asset sales?
It's a good question.
What new challenges might come up?
Yeah, what about opportunities?
For consumers and companies.
It's a complex field.
With a lot at stake.
A lot at stake.
Those are some great points to think about.
I think so.
We learned a lot today.
We did.
This deep dive has been really eye-opening.
Yeah, it has.
Thanks for breaking it all down for us.
My pleasure. Always happy to talk about this stuff.
Until next time, then.
See?